I'm Velshi with MSNBC. This past week, the Supreme Court heard oral arguments in Lange versus California. The case asks whether a police officer violated the Fourth Amendment when he entered the garage of a person suspected of a misdemeanor crime. The officer did not have a warrant, but claims he was in, quote, hot pursuit of the suspect. It's a subject of this week's A More Perfect Union with the National Constitution Center. Jeffrey Rosen, the president and the CEO of the National Constitution Center, joins me now. Jeff, good morning. I know we are likely to be waiting several months to hear how the court comes down on the issue, but give me a sense of the political implications on policing, on privacy, and the Fourth Amendment.
Well, this is a hugely interesting case, and the question is, every time the police suspect you of a minor crime, are they allowed to follow you into your house without a warrant? In this case, the guy, Arthur Lange, was playing music loudly. He didn't see the officer, so he didn't stop when the officer flashed, goes into his garage. The officer stops the garage door and basically tests him for alcohol. And the question is, do you need a warrant for that? Now, the government says every time you go into your house, if the police are following you, that's hot pursuit, and the police shouldn't have to get a warrant. The other side says this means that if the police are following a bunch of scared teenagers and the teenagers go into their own homes, the police should be able to go into their homes without a warrant. The broader question, which has big implications for the future of policing, is should there be some requirement of proportionality between the seriousness of the offense and the intrusiveness of a search? In other words, the police might be able to follow you if you're actually running away with a gun in your hand, but if it's a minor misdemeanor, maybe they should have to get a warrant. Now, later this term, the court may hear a case involving, can the police search a computer or a cell phone at the border or a laptop? That has huge implications. And once again, the question is proportionality. A computer search is so intrusive that maybe you should have to have a higher degree of suspicion than merely the fact that you're at the border. What's so interesting about this case, Ali, is that it does not divide the court on partisan lines. The court unanimously held a few years ago that the police cannot search your cell phone when you're arrested without a higher standard of cause because we have so much personal information in our cell phones. Some of the justices, like Justice Neil Gorsuch, think that there should be some sort of private property violation before the police can commit a search. Others say that you have an expectation of privacy in your data, whether or not there's a property interest. But we could see in this Lange case, a unanimous or at least a bipartisan decision in favor of Mr. Lange, and that would be a huge victory for the principle of proportionality and the future of the Fourth Amendment.
What a remarkable topic. Thanks, as always, Jeff. Jeff Rosen is the president and CEO of the National Constitution Center.